Okay, so we weren't able to get to all of your questions during the webinar with Nick Zano. What we're going to do is do a rapid fire and go through the remaining questions at this point. If you still don't hear the answer to your question, you can always still send me an email at diane.mokrisky@cbia.com. So let's get started and we'll hit the questions we didn't originally get to.
Number one, as a manufacturer and first year participant is January 1st, 2025. We want to use one bucket, which is allowed for PTO time. Everybody is on an anniversary date of hire for PTO. So coming into 1/11/2025, some people may have used up all their PTO time and others have some PTO time, but appears by the law they need to have at least 40 hours available if they have been here for more than 120 days. Any suggestions on how we coordinate using one bucket for the first year of the program? Once we get past their anniversary date, renewing in 2025, they will be fine for the advance hours, but not until that point.
Okay, so this is actually a really good question, and it has to do with that strange requirement that starting January 1st, 2025, on that day, January 1st, employees start accruing their PTO. And so that can seem a little awkward if your policy up until that point has been that people accrue and use their PTO based on their anniversary date. And so in this case, for this first year, that's going to be a little bit awkward. So let's say my anniversary date is April 1st, right, in 2025. Even if I've used up all my PTO beginning on January 1st, 2025, I get to start accruing PTO little by little, even though my anniversary date doesn't really start until April 1st. And so during that lag of time between January 1st, 2025 and your employees' anniversary dates, you do have to let them still accrue according to the law, or just front load everyone's PTO beginning January 1st. If you really feel strongly that you want to let people still, you would prefer to use anniversary dates, then I guess what I would recommend is that you have people accrue their time according to statute, little by little, starting in January. And then when they reach their anniversary date, then give them all the PTO that they normally would have had. Okay.
So right now we require documentation for 3 consecutive sick days. Does this mean we need to remove this from our policy?
Yeah, so regarding the documentation, I know that that is a really common policy that if someone's going to be out for 3 days, you ask for a doctor's note. You cannot do that anymore. And so I know that that involves maybe a little bit of conflict with FMLA, and we can talk about that a little later when those questions come up. But as of now, if you have an employee who's going to be out for 3 days, you don't ask them for a doctor's note.
What if you have separate sick time and vacation time?
All right, so you can still separate out. It's up to you. If you would like to separate out PTO, vacation, sick, that's fine. You can also group it all together in just one lump bucket known as PTO. That's your call. The only requirement is that you have to allow at least 40 hours per year for sick time. So you could have a policy where you have 40 hours of paid sick time plus PTO separate. And one of the advantages of that might be that for the PTO, you have lots of rules about when you can use it and under what circumstances, when the statute really doesn't allow you to have those rules for sick time. So that might be one of the advantages, one reason why you might want to separate them out.
Can an employer still counsel employees who know they have a doctor's appointment in advance and don't tell their employer?
Yeah, I assume by counsel, you mean discipline them in some way or write them up. Yeah, so you can have a policy. We were talking about this to some extent during the webinar. You can have a policy that asks your employees to give you notice of their need for sick leave. And if they don't give you notice, you could discipline them for that. It's tricky though, because you cannot discipline them for taking the sick leave. So for example, let's say someone you know that someone was having surgery and they didn't tell you and they took 2 days off, you could discipline them for not letting you know that they were having surgery, but you wouldn't be able to discipline them for actually taking the 2 days. So you kind of have to just be careful about that. There's some nuance there.
Can you example the seasonal eligibility a bit more? We have a summer intern program. Would those employees be eligible?
So, interns are not really separate from employees. It kind of depends what you mean by the word intern. If you have someone who's working for you and you're paying them and they work for you the minimum number of days per year, which is 120, then that person becomes eligible for paid sick time. It doesn't really matter that you're calling them an intern. If they work for you for 120 days, then they become eligible for paid sick time.
If you have just PTO, are you required to differentiate when it is taken for sick for record keeping purposes?
No. So we were talking about how you have to keep records on pay stubs. That is required by the statute. You keep a record of the accrual of the sick time and the usage of sick time. If you're just calling it PTO, but they can use it for sick time, then that's fine. On your pay stub, you just keep track of the number of hours that they've accrued and the number of hours that they've used.
If you have to track the sick time but have a bucket PTO policy, do you have time to specify the hours used for sick time separately? Or can you just provide the PTO time available used?
You don't have to track it separately, no.
We currently accrue hourly with PTO, so this means we would need to make sure the hourly accrual meets the 1 hour for 30 hours per week, correct?
Yes.
We have a policy that employees must turn in a doctor's note after 3 missed days of work to confirm. We can't require this if we have a bucket type PTO.
That's right.
If employees uses their PTO for vacation and have none left and are out sick, is that considered CT sick and does it have to be paid?
No, they have 40 hours available to them for paid sick leave, and that's it. If they use it all, then they've used it all and they're not entitled to any more.
If you have a general PTO policy of 40 hours that doesn't specify vacation or sick, that's all you need?
Yes.
Temporary employees through an agency versus seasonal. Is the agency responsible or the employer?
The temp agency is the agency that employs the worker, so they're responsible.
Can you review the carryover process? Does it always equal 40 hours or does the carryover give them more hours of sick leave?
No, at the end of the calendar year, if the employee hasn't used some of their accrued PTO, you carry over what they have not used. That's it. You don't necessarily carry over 40.
What about temporary workers that are contracted with us through a staffing agency and are paid by the staffing agency?
The staffing agency is then in charge of keeping track how long they've worked for them and how much sick time they're entitled to.
Does the 120 days a year count for our company only? Because what happens if they have multiple jobs?
It's only for your company. You're counting 120 days just from you.
Does it matter if our PTO is called vacation, but it meets the sick leave requirements, can be used for anything in any increments, and is front loaded for a minimum of 80 hours a year?
That would comply with the statute.
What if they are being paid by a temp agency and not eligible for any benefits, such as PTO through us? Are they still to be counted?
They would not be counted as one of your employees. They'd be employed by the temp agency.
What is the accrual rate? Again, 1 hour earned for how many hours worked?
1 hour of paid sick time for every 30 hours worked.
If we change to a PTO policy, do we need to allow carryover?
It's not a matter of changing to a PTO policy. Whether you have a general bucket of PTO or not, you have to allow unused sick time to carry over to the next year.
For seasonal employees, is 120 days a year or total overtime?
It's 120 days per year.
The posting requirement is January 1st, 2025. Is that also for employers that are not included in this due to the employee size until January 1st, 2026?
Yeah, so once you become subject to the law, so if you've got 25 or more employees, it's January 1st, 2025. Once you're subject to that, then you have to post and distribute the notices. If you're not subject to the law until 2026, that's when you post and distribute the notices.
You mentioned employers are no longer to ask for doctor's notes effective January 1st, 2025. Is this if the employee is utilizing Connecticut paid leave request at 60% of their salary? Is the employer good to ask for a doctor's note after 3 consecutive days if the employee is paid by the employer at 100%?
All right, so that question has to do with Connecticut paid leave, which is a type of Connecticut FMLA leave, and that's a completely separate statute from what we're talking about here. The 60% and the 100%, those all have to do with the paid leave authority and AFLAC, and so I'm not going to address that here. That's a different issue.
What if you provide a minimum of 40 hours PTO to part-time employees? Do you have to provide sick leave?
No, not in addition to the 40 hours.
If we front load PTO hours, we don't have to allow for rollover, correct?
That's not correct, whether you front load it or not. If someone has unused paid sick time at the end of the year, it rolls over to the next year.
If we hired part-time and full-time employees as of January 1st, 2025, does that mean they accrue sick time bucket PTO immediately instead of waiting the 2-month introductory period?
Yes, they start accruing it immediately.
If an employee is out for more than 3 sick days, can an employer request the employee to apply through Connecticut paid leave?
No,
If rehired, do you need to give back the time previously accrued or start at the beginning?
if you're rehired, you start accruing at the very beginning, but you keep the days that you've already worked. So you don't have to wait 120 more days to be eligible, but you start accruing at 0. And so with the first 30 hours, you get your first hour after rehire.
Regardless of how many days someone works as a temp prior to January 1st, they start fresh on January 1st?
Yes.
We front load 18 days for each employee times the number of hours worked each day. Full-time employees have 144 hours front loaded each January 1st. If part-time and work day 5 hours per day, they would have 90 hours front loaded on January 1st, which they are eligible to take immediately. Part-timers who do not work 25 or more hours per day do not get any PTO. I imagine we will need to change that for January 1st, 2025.
Yeah, the only thing you have to change about that is the very last part where you say that the part-time workers don't accrue any paid time off. Whether you're full-time or part-time, you still accrue paid time off at the same rate, which is 1 hour for every 30 hours worked.
If we front load the 40 hours on January 1st, 2025, and we track it in a separate bucket, can our existing PTO, vacation or personal time off, policy still apply with regard to asking for doctor's notes, giving notice and the reasons for using the PTO, etc.? Would this be compliant with the law if we keep them separate?
The first 40 hours of paid sick time are the hours that have to comply with the law in terms of not asking for documentation and accruing it at the correct rate. If you have separate vacation time and PTO over and above that, then the rules don't apply to those additional hours.
If you use a PTO bucket, what would be the best way to track sick time leave if an employer could be audited on this? If we're not able to ask for documentation or anything of that sort, how do you track this usage for the state to audit? Do we have to ask for a reason from them? No documentation, but at least a reason?
If you use a PTO bucket, which means that you're not distinguishing between sick time and vacation time, then you really don't have to track it at all. You just have to provide 40 hours of leave that's available for your employees. And so you keep track of how much they've used of that 40 hours.
You already addressed this a bit, but how do interns figure into this?
Interns really aren't any different from other employees. Once they've worked for you for 120 days, they begin to be eligible for paid sick leave.
Are the employer required to carry over sick time balances year to year?
Yes, any unused sick time carries over to the next year, but it would never exceed 40 in any year.
Our accrual is a half day accrued for every pay period, 80 hours. Do we now have to give 2 hours plus for the 80-hour period?
Yes.
If we have no fall attendance policy, are we permitted to discipline for absences that are taken under this statute?
No.
Can you please clarify the 1 hour to 30-hour work accrual, but capped at 40?
So you accrue 1 hour of paid sick leave for every 30 hours that you worked. But once you've accrued 40 hours of sick leave, that's where it's capped and you don't get any more, even though you continue to obviously work.
What if we give them 80 hours PTO and the employee chooses to use them as vacation time? Do we still need to pay them 40 hours sick time?
No.
If we give an employee 40 hours of PTO, are we still in compliance? Would the employee be able to use any of these hours for vacation?
Yes, if you have a policy that provides at least 40 hours and you can use it for either vacation or sick, then you're in compliance.
We have blackout periods. Does this mean now if they say they are sick, we have to let them take time off during this time without question?
Yes.
Currently, our PTO policy accrual rate is based on 40 hours for full-time employees. Now that part-time employees are included, do we change the accrual rate for everyone to 30 hours?
Yes.
If an employee has only accrued 20 hours but needs to take 40 hours of sick leave, is the employer obligated to allow them to go into the negative?
No.
We currently offer 5 days of non-paid sick time and a max of 15 days for vacation time. Can we change our vacation policy to now read PTO max of 15 days and delete the 5 days of non-paid sick time?
Yes.
To clarify, regular employees are 120 days from date of hire, not 120 days worked. Seasonal employees is 120 days worked.
Yeah, that's right. So there's two different things. Seasonal employees have to work, not calendar days. They have to work 120 days before they become eligible to use their paid sick time. Now, put aside seasonal employees, we're talking about regular employees in quotes. Once a regular employee is just employed by you for 120 calendar days, then that employee can start to use the paid sick time that they've been accruing over those months.
How would we know if they are using the time for sick leave if they are not required to provide a doctor's note?
You don't really know.
If we require employees to be present during a high production season and an employee unexpectedly misses work due to illness, can we request a doctor's certification if their absence exceeds 3 days?
No. Well, yes, if that absence ends up being an FMLA absence, but for paid sick leave, which is only 5 days or 40 hours, no, you don't ask for a doctor's note.
What is to prevent an employee from taking advantage and using all of their sick days and then vacation days later, potentially for payout? Can we ask why are they calling out multiple days?
Well, if you limit the amount of leave available to just the 40 hours, then there's no way for them to take advantage. They just use their 40 hours, and whether they're sick or not, once they use it, they've used it, and there's no way to take advantage. If you want to give them more than 40 hours, then anything over and above that initial 40 hours, you can restrict however you want with documentation, doctor's notes, whatever.
For the 1 hour use of increments, if they are only out for 45 minutes, does the employer count it as an hour of use?
Yes.
An employee doesn't have to provide documentation as to why they are taking time off, even after 3 days off?
That is true unless it becomes an FMLA absence, which is typically 4 days or more.
If we front load the 40 hours on January 1st, 2025, and we track it in a separate bucket, can our existing PTO policy still apply with regard to asking for doctor's notes, giving notice and the reasons for using the PTO, et cetera? Would this be compliant with the law if we keep them separate?
Yes.
If we just have a PTO bucket and require advance notice to use PTO, now we want to add an additional 40 hours for paid sick leave into the PTO bucket. Are all the hours in the PTO bucket required to follow the paid sick leave rules where no notice is required?
No. So that rule, the rules that say you can't ask for doctor's notes, all the restrictions, they only apply to the first 40 hours.
Since we are no longer able to follow any company policy in place regarding absences and physician documentation, how will we know that an absence is eligible for paid sick leave? Especially if this can supposedly run concurrently with FMLA, since FMLA, we can require a release to active duty work notice.
You don't really, you have to rely on your employees telling you why they're absent. And if you don't believe them, there's really not a ton you can do. For those first 40 hours, you can't ask for a doctor's note. And so there's not a ton you can do. If they're absent more than 3 days, that's when FMLA may come into play, and then you can ask for a doctor's note.
If a part-time employee is hired in 2025, works less than 120 days, say 100, leaves, then is rehired in 2026 or sometime thereafter, do they still start over at day 1, or do they return with 100 days in the bank and then only need to reach day 21 to be eligible?
When they are rehired, they get the credit for the number of days that they already worked for you in the past.
Do we have to allow for sick time to roll over?
Unused sick time rolls over, yes.
Apologies, I know you said this already, but just to confirm, the minimum requirement is that a new employee must wait 120 days before they can use their accrued sick time.
Right.
Do you have to let them carry over 40 hours PTO if they're going to get a new 40 hours PTO on their anniversary date?
It's not that you carry over 40 hours, it's that you carry over the hours that were unused. And then there's a cap for the year, you only get 40 hours. So let's say at the end of the year, they had 20 hours that they never used. You'd carry over those 20. The max for now that year will still be 40. So if they get additional hours on their anniversary date, you would just cap it so that the total number of hours for the year is 40.
Since we need to allow carryover, we can say something like this in our handbook. Employees will be allowed to carry over sick time into the next year, but at no time can have over 40 hours sick time at the start of January 1st if we use calendar year and we front load.
That's right.
Can you require documentation after they are all done with their 40 hours of sick time?
Yes.
If you are able to carry over 40 hours into the next year, and that happens for 2 years, in year 3, would that mean the person has 80 carryover from 2 years prior and 40 for that year, totaling 120 hours for the 3rd year?
No, you only carry over hours 1 year at a time. So you can carry over unused hours into the next year. But remember, there's a cap of 40 hours per year. So it doesn't continue to accumulate year after year.
If you're going to keep your PTO time because it fits the criteria, do you just need to add a line in the policy acknowledging it in the policy that this fulfills the requirement of the new Connecticut sick law?
You could do that. You don't even really have to do that. If your PTO policy complies with the sick leave law, you can just be confident in that, and you don't even have to say so in your handbook.
Another temp agency question. The law states 120 days from the time of hire. But what about an employee who's working for an agency and has several start dates on different assignments with breaks in service? Does the clock reset each time, or is it a total of 120 days between the assignments?
The worker is employed by the temp agency, and so regardless of where they're assigned to work, the employer is the temp agency, and so it's that agency that's going to be counting the days, counting to 120.
And so they're counting the days they're on assignment, or just the days that they are
so if you're
contracted by the agency?
If you are the temp agency, if you're asking this question because you're the temp agency, then you're keeping track of how many days that worker works for you. So you wouldn't count days that they don't have an assignment. You're just counting the days that they're working. And once they've worked 120 days for you, the temp agency, they then become eligible for paid sick time.
So essentially you're treating them as a seasonal employee.
They're seasonal they're seasonal / temporary until they've worked 120 days.
Is Mental Health Awareness Day a requirement?
Yes.
Currently, if someone is out for 3 consecutive days, we require a doctor's note. Can we no longer require a note?
That's right.
Do employees have to state sick time? We automatically pay sick time if they are gone 1 hour or more if they have it available.
I think it would make more sense if you did require your employees to tell you why they're absent so that you can track the number of hours they're using for sick time. The distinction there is that if the employee is absent for something that has nothing to do with sick time, like their car broke down, then that absence is not protected. It could be unexcused and it could be a reason for discipline. So you kind of want to distinguish between the reasons for the absence.
Is the mental health day included in the 5, or does a person get 5 sick and 1 additional mental health?
The mental health day is included in the 40 hours.
Confirming, Connecticut sick time accrues for full-time and part-time at 1 hour for every 30 hours, up to 40 hours per year. Seasonal are not entitled to sick time if they work less than 120 days, correct?
That's right.
Relative to tracking sick time are reports generated by the payroll system, ADP, paycheck, etc., sufficient for Connecticut Department of Labor auditing requirements, or does the employer have to track by some other mechanism?
You can use ADP or paychecks as long as that electronic system indicates how many hours of paid sick time the employee has accrued and used.
Can we still ask for documentation for fit for duty and safety issue? And what about the day 2 and 3 of workers' comp?
So remember, you can't ask for a doctor's note to substantiate the reason for the absence, but if you have a reason to believe that your employee is not safe and you have a reason to believe, like if you're concerned that they're not fit for duty, you can ask for a fitness for duty note. All of this that we've been talking about regarding paid sick leave is completely separate from the workers' comp statutes. And as you were referring to, workers' comp doesn't start until after day 3, and so that wouldn't be relevant at this point.
If you combine into a PTO policy and provide 80 hours as one bucket, can we just rely on the employee telling us if they are taking it as a sick or PTO? And if they decide to use all 80 hours as PTO time, we have no further obligation to give sick time then.
Correct.
We have a use it or lose it policy. All time is front loaded each new year. Do we still need to allow up to 40 hours rollover?
You don't have to roll over 40 hours, but you have to roll over the hours that they don't use. Now, if you provide 80 though, you don't have to roll over 60 if they only use 20. You have to remember the minimum that you have to provide is just 40. And out of that 40, if some of that is unused, that's what you roll over to the next year.
How often do we have to report total sick time and used to the employee? Is it weekly or annual?
It's something that you keep track of in real time, and it's something that appears on their pay stub. So it's a constant obligation.
Can an employer require a doctor's note if we suspect abuse? How does this interplay with a CBIA that allows us to require a doctor's note?
It doesn't matter if you have a collective bargaining agreement that requires a doctor's note. This law supersedes that. And so since this law says you can't require a doctor's note, that stands. Unless, if you listen back to the webinar, there's a very specific carve out for certain types of collective bargaining agreements pertaining to construction workers. But assuming that's not you, the existence of a collective bargaining agreement doesn't change the fact that you can't require a doctor's note. And then what was the second part of that question?
How does this interplay with a collective bargaining agreement that allows us to require a doctor's note?
Okay, you can't require a doctor's note.
Technically, we have to separate sick time from PTO because of the record keeping.
No, you don't really have to separate it out. You just have to keep a record of the time that an employee has used. It's okay if they use it for PTO, as long as you give them 40 hours.
If the company closes due to a storm, either for the full day or closes early, can staff use the Connecticut paid sick leave to get paid for that time? In the past, we have only allowed the use of vacation time for this purpose, not sick time. We have 2 separate buckets.
If your business shuts down due to a storm, then that's not one of the triggering reasons to use paid sick time. So it's not really a matter of whether you can let your employees use paid sick time. It's that you wouldn't want to require them to use it. That's not one of the eligible uses for paid sick time. So you'd want to allow them to have that paid sick time to use for the actual eligible reasons.
For seasonal employees, is it 120 days from the date of hire or 120 days worked, even if it takes longer than 4 months?
Yeah, it's 120 days worked, and that will take longer than 4 months, probably.
If you front load all time, do you still need to record accrued hours as they happen?
Yes,
Is the prohibition on requiring a doctor's note only applicable to the first 40 hours of sick?
right.
When you say we need to track sick time usage and accrual, if I'm front loading the 40 hours at the front of each year and people can utilize their sick time as needed, what do I need to track?
You just need to keep track. So on the pay stub, let's say you front loaded 60 hours, the pay stub would indicate that there were 60 hours available. And as those hours were used by the employee, you would indicate that on the pay stub as well.
What happens if you give 80 hours PTO and an employee use it all for vacation? Do I have to give them an additional 40 hours sick?
No,
But if they take all 40 hours of sick leave, how do we know if they're fit for duty?
there would generally be no reason for you to presume that they're not fit for duty. Paid sick leave is really just meant for minor sicknesses like the flu or the cold or something like that. And so even if they've been out 5 days, unless you see something that's really concerning, you can presume that they're fit for duty and not require that note.
If we currently offer front-loaded 5 days of sick time and 15 days of vacation, will we need to offer an additional 5 days of sick to comply?
No,
If they are out of work for outside of work injury, can you request the fit for duty note?
yes,
Is seasonal / temporary taken into account part-time workers?
yes, it's all seasonal, temporary. Yes, if you are a part-time worker, the rule is still the same. You work 120 days, and once you've worked 120 days, you then become eligible for paid sick leave.
Second part of that question, what if someone is under 30 hours a week but worked more than 120 days?
Okay, so once they've worked 120 days, they're no longer seasonal, they become a regular employee and they're eligible for paid sick leave. But they're accruing, then you look backwards at all the time that they've been working for you and you see how many hours they've worked. And they're gonna be accruing it pretty slowly if they're working fewer than 30 hours a week.
We are at HVAC trade and techs are required to lift, move heavy equipment. How can we not require a return to work note that clears them?
Even though you can't require a doctor's note, it does matter in this scenario why they're absent. So if they either have an at-work injury or some injury that affects their ability to do the job, then yes, you can ask for a fitness for duty note. But if they're out sick because they have the flu, then that's really what this statute is meant to cover, and a fitness for duty note is not implicated.
What if the employee accrues 80 hours of PTO, uses 40 hours of vacation, 40 hours for car problems? They used no time falling under sick time, but they had available. Does that count?
In that scenario, you've provided all the leave that you would need to provide.
If on January 1st, 2025, we only have 23 employees, but during the year we hire a few more people, are we compliant to start accruing paid sick leave on January 1st, 2026?
Yeah, the date that you want to pay attention to is January 1st of each year. So if you have 23 employees on January 1st, 2025, you don't employ enough people to be subject to this statute. But if during that year, the year 2025, you hire a few more people, and the result is that on January 1st, 2026, you employ more than 11, and then at that point, you are subject to the law.
What if we give 120 hours PTO and the employee uses it all for vacation, and then before the end of the year, they are out sick? Do they get additional sick time?
No,
But I have a construction company, and if they say they're hurt and need to take time off, can I get documentation for fit for duty? Hence, if they're in a car accident and have a concussion.
yes,
If we don't track PTO usage on the pay stub and is managed by managers, does that comply?
no.
So if you have PTO and those hours can be used for anything, then how do we track what hours the employee is taking for sick time? Can we ask them when they call out what is being used for sick or vacation?
So it's important to just distinguish why you're keeping records. On the one hand, there's a responsibility to keep records for the labor department. That's when you keep records on the pay stub indicating how many hours of leave the person has available and how many hours they've used. That's a statutory requirement that's on the pay stub. What if all you have is PTO? You don't need to keep track of whether it's sick or PTO. You just keep track that you've given the hours and they've used certain hours. Separate from that, you might want to keep track of why people are absent, because certain absences won't be protected and they'll be unexcused, like car trouble.
So then we must break it out. If we have to track how much sick time they used, the only way to prove it is to have them code it that way.
You don't have to really code it that way. You only have to code that you're providing time off and that they're using that time off.
When you say that no notice is required for using it, does it mean the day of? For example, my work requires a 2-hour notice when possible. Can I no longer require that?
No, you can still require that, but remember there's a difference between disciplining someone for failing to follow that rule and disciplining someone for taking sick leave. So you can require that they call in within 2 hours, and if they don't, you can discipline them, but they still get that time off.
Does the 40 hours include the 1 day for mental health? Do we really have to give them 48 hours?
No, you give them 40 hours and the mental health day is included in that.
What happens if someone wants to use PTO for all vacation time? Do we have to deny them the 40 hours PTO because it has to be used for sick?
No,
Can we ask for a doctor's note after they have used 40 hours sick time?
yes.
If we track employee hours via timesheets, when they define PTO sick used, am I required to split their pay stub into 2 buckets as well? We have mostly salary and a few hourly. Traditionally, we haven't split the time out on pay stubs.
You don't have to indicate on the pay stub the difference between vacation and sick time.
If you front load 40 hours at the beginning of the year, do you still need to track the accruals?
Yes.
We give PTO at this time to people who work over 35 hours a week. Our own policy. What is the threshold for part-time workers? Maybe under 30 a week. For example, if someone works 10 hours a week for a year, do they qualify to get 1 hour for every 30 worked?
Yeah, the rule is the same. It doesn't really matter whether you're part-time or full-time or how many hours you work in a year. You keep track of the number of hours the person is working, and once they've worked 30, they get an hour of paid sick time.
Can we have them use the 40 hours PTO/sick pay before they collect paid FMLA?
Regarding paid FMLA, that will likely only come up once the person has been absent more than 3 days. So it's not that you would yes, I guess is the answer. You would require them to use this paid sick leave first, and then FMLA and paid FMLA would trigger after that.
Is it correct that if we have a no-fault attendance policy, we cannot discipline for any reason until they have used their 40 hours sick time? If they are tardy 30 minutes, do we have to give them 1 hour sick time?
It's not that you can't discipline them for any reason. You can discipline them if you learn that they're taking time off for reasons that aren't included in the statute, like they're not actually sick. If you learn that, you can discipline them for that. You can also discipline them for not giving you the notice that you require. If someone's tardy 30 minutes, no, you wouldn't be using paid sick time for that. First of all, I mean, you can require that it be used in 1 hour or more increments.
If someone uses all their sick time and misses additional time that's unpaid, can a note be required?
Yes.
Please explain the 3 or more days, then documentation is acceptable piece.
The only time you can require documentation is when it's for an FMLA absence. And so that's why we were saying in the webinar that if it looks like it's going to be an FMLA absence, you can then require a doctor's note. And most FMLA absences occur after 3 days.
If someone doesn't come to work for 3 days and is a no call, no show all 3 days, are we still able to separate employment, even if the reason could be sick reasons, but we don't know because they didn't reach out to us?
So what I would recommend you do in that case is connect with that employee and find out why they were absent, because it could be that they were in the hospital or they really were sick. And so you wouldn't want to fire that person because that would be a legitimate reason for them to be out, and that it would be a protected absence. If you try to reach out to them and you don't hear from them and it really just becomes a no call, no show, then that can be a reason for separation.
Does the 1 hour increment of sick time take effect January 1st, 2025, or is this already the law?
Nope, this takes effect January 1st, 2025.
Can we send the notice out sooner?
Yes, but you'd want to make sure that the employees know that this takes effect January 1st.
If we have 22 employees on January 1st, 2025, but in August, we may have 26, then we don't have to do this until 2026?
Correct.
The 3-day note is to prevent people from just calling out.
A 3-day note. 3-day note refers to a really common practice that employers have that says once an employee is absent for 3 days, they ask for a doctor's note. And so we were saying that you can't do that anymore.
If an employee notifies us an hour before their shift that they will be absent for personal reasons, can we require them to take the entire day off instead, since we might not be able to accommodate them working beyond their scheduled hours?
I mean, you would want to tell them that if they're out because they're sick or they're taking care of someone who's sick or for any other of the reasons outlined in the statute, you'd want to let them know that they can take paid time off for that reason in 1 hour increments. If they say, no, this is just personal time, then that's not covered by the statute, it's not protected, and none of the rules of the statute apply. Then it becomes your discretion on what your policy is for that.
Can we ask for doctor's notes if they've exhausted 40 hours paid sick leave?
Yes.
Are we allowed to ask if their absence will apply to paid sick leave? How do we know when to apply it?
Yeah, you can ask them why they're absent.
Once an employee exhausts the employer eligible sick time policy, is the employee to apply for Connecticut paid leave for any and all sick time? Example, 1 hour, 1 day, or days.
Once the employee has used all of the paid sick time that we're talking about today, it may be that their illness is serious enough to qualify for Connecticut paid leave, which is separate from this. Connecticut paid leave is what you get when you're on FMLA leave. And it may be that they would be eligible for very short increments of paid leave, like an hour or half a day. It kind of depends on what the condition is.
If we have a general 4-week PTO policy that is all inclusive and an employee uses it all for vacation, do we still have to provide additional paid sick time?
No.
Can the notice be given to employees in writing instead of emailing it to them?
Yes.
Our PTO starts at 80 hours annually. What if the employee doesn't use the 40 hours sick time? Can they use the time for other purposes?
If your policy allows them to, yes.
We currently have just PTO. Can we give the same amount but lower the PTO by 40 hours and add in 40 hours sick time beginning January 1st, 2025?
Yes.
If we only give 40 hours of PTO and someone uses it for a vacation day in advance, do we deny it so that they can accommodate for sick leave?
No, it's really up to the employee. If you make it clear to the employee that they're only gonna be allowed 40 hours, and if they wanna use that for a vacation, then that's up to them. It won't be available then later for sick days.
If you offer the employees the 40 hours, but they choose to use it for vacation time and then towards the end of the year have a need for a sick day, does the law no longer apply because they chose to use it for other reasons?
Right.
If we give them 80 hours PTO and they can roll over 40 hours, if they don't use any time off that year, do we now have to let them roll over 40 for sick and 40 for vacation? So 80?
No, you may not ever roll, it may turn out that you don't even roll over 40. You're only required to give 40 initially in the course of a year and roll over what's not used out of that 40. And each year, the maximum amount you have to give is 40 hours.
So if an employee works 1 day a week, then they will be eligible after 120 weeks.
So there's a difference between a seasonal employee and a regular employee. And so if the employee is not seasonal, then they're eligible to use their paid sick leave once 120 calendar days have gone by and they've been your employee for 120 calendar days, even though they only work 1 day a week. Keep in mind, if they're only working 1 day a week, they're accruing paid sick time really, really slowly. So you could keep an eye on that.
Can we give the option of carryover or payout?
Yes.
We have a PTO policy for 160 hours. Now that we will have to track if they have used all of their 160 hours, but are not all 40 hours sick, do we have to grant them more time if they now claim to be sick days?
No, you don't ever have to give more than 40 hours total, as long as any of those 40 hours can be used for sick time.
So if they carry over all 40 hours until next year, they don't get another 40. It's only 40 total.
Correct.
If they are allowed to roll over the 40 hours, how long do they have to use it in the following calendar year? Just January or through February, March of the following calendar year?
No, then they have it kind of depends how you as the employer, how you're counting a year. But if they roll over 40 hours, and so they have that available on January 1st, and you're using the calendar year to count years, then they'd have that entire calendar year to use the 40 hours.
And final question, we had a couple people write in if you could further discuss the carryover rollover.
Yeah, so keep in mind the reason for the carryover rule is for those employees who might need to take their paid sick leave in January. So let's say you're accruing these paid sick hours little by little by little. And so throughout the course of the calendar year, maybe you're sick, but you're thinking to yourself, I'm going to save it. I'm going to save it. And so by the end of the calendar year, let's say November or December, you have finally accrued your 40 hours, but you don't want to use it at the end of the year. You think you might need it in January because you always get sick in January. So you can carry over those hours into the next year. And then in January, you'll have a bucket of 40 hours ready for you to use in January. If there weren't that rule about having carryover rights, then remember January 1st, you're usually starting from scratch. You got to work 40 hours to get 1 hour of PTO. So the carryover rule is a way for employees to have access to paid time off really in the beginning of the year. That's the point.
And so if you're an employer who just gives 40 hours at the very beginning of each year, you don't really have to worry about the carryover.
Right. I mean, if you're just going to front load everybody and you're going to give everybody 40 hours on January 1st, you don't have to ever worry about carryover.